Hey guys, today Madison, Elijah, and I are going to be telling you about pretrial processes. So, the first step of the pretrial process is the arrest and the booking. A person may be stopped for suspicious behavior. This stop usually occurs when a police officer is called to a scene or witnesses a crime being committed. In other cases, a police officer may stop and frisk. This stop and frisk comes from Terry versus Ohio, which allows police officers to stop people on the street if they have a reasonable suspicion that a crime may have been or will be committed. This can lead to an arrest, and the pre-trial process begins at the original arrest. So, when an officer formally arrests someone as opposed to just detaining them, there has to be probable cause. Sometimes an arrest warrant can be issued by a judge as well. After the arrest, a person is put in handcuffs, they're brought to the police station, and read their Miranda rights. At the police station, their fingerprints and mugshots are taken, and then they wait for an attorney and or give a statement to police. The person must be formally charged or released on discretion of police and the prosecutor based on the evidence in a certain amount of time, or they have to be let go. So, as I just mentioned, your Miranda rights will be read if you're arrested. Miranda rights actually stem from Miranda versus Arizona, which was a 1966 case in which Ernesto Miranda, who was arrested and convicted of rape and robbery, um, provided a written confession at the police station. However, his case was appealed to the Supreme Court. He was claiming that his rights were being violated. He only had an eighth grade education, and he wasn't made aware that he had a right to remain silent. The Supreme Court actually ruled in Miranda's favor, stating that the Fifth Amendment right to due process was violated. And so these rights are the right to remain silent. Anything you say can and will be used against you in a court of law, which the key word there is will be used against you. You have the right to an attorney, and if you can't afford one will be provided to you, except for in some cases. And you have to either waive your rights or you have to say that you understand them and you're going to choose to remain silent. Miranda rights include that you have the right to counsel, but it doesn't necessarily mean that counsel will be provided to you. Gideon versus Wainwright was a 1963 case that led to the Supreme Court ruling that indigent, meaning poor, defenders must be issued counsel if they want it, whether or not they can afford it. If you truly cannot afford an attorney, a public defender will be assigned to your case. Feely wrote about this in the assigned reading from this past week. Private attorneys are incredibly expensive, and this is one of the reasons why arrestees might not want legal counsel. If you're within a certain financial bracket, you must provide your own attorney, and if the court determines that you cannot afford an attorney, you'll be provided with a state attorney. But most of the time, 9 out of 10 times, these people are overworked and under resourced. So prosecutors will often tell arrestees that they can either get an attorney, sit in jail, wait to go to trial, all of that, or they can just get it over with today with a plea bargain.
So, a plea bargain is basically a way to resolve a case without it going to trial. So, with the plea bargain, someone would plead guilty or no contest in exchange for dropped charges or a less serious charge. And there's some examples on the side there about John that you can have a look at. And it's sort of like an alternative to, going to trial and doing this whole long, drawn out process. They can just get it over with right there. And, many cases don't go to trial. There's a pretty shocking number. I think it's somewhere in like 90%, don't quote me on that, don't go to trial and end in plea bargains. But going on with public defenders, the sort of thing is that they sort of like this kind of thing because, we see it everywhere in the movies, TV, it's common knowledge. They're overworked and just have a crazy caseload of, hundreds of cases. So, it would seem likely that plea bargains are popular because they get it over with quickly. So there's some possible advantages with a plea bargain, and one of them being, it's sort of better for everyone in the way that, you know, nobody has to use their time, energy, and money in this long process when they can just get it done right there. And another advantage, would be the sentencing part. You know, if you go to trial, you run the risk of getting a harsher punishment than you would have, if you'd have just taken a plea. And and another one is, you could avoid incarceration altogether. It could just be like probation and fines if you plead guilty. So, on the other side of that, the big one is obviously innocent people may choose, a plea bargain and plead guilty, even though, when these people are actually innocent. And now, they're labeled and they have a criminal record. Another thing is that, there's this sort of big pressure to accept it because if you're looking at a murder charge and they can bump that down, to a manslaughter, it would seem like the obvious choice. And the last thing here, it's talking about how, it can basically give prosecutors, a win, because if they had a weak case and it went to trial, they probably would have lost. But with the plea, it sort of saves them.
So, what does it take to go to trial? It depends basically on who's being convicted. If a person committed a criminal crime, then they're going to have to come up with a lot of evidence to support why he did the act that he did. If it's just an institution, they might just want to pay off the worker and get out, and it might not even have to go to trial. So, but in this sense, courts do get filled up with many different trials. So, if you wanted a trial date against somebody or something, then it might get placed way in advance because they will probably be overwhelmed with a bunch of other trial dates that they have. But then you also have the parties, the witnesses, the lawyers, and the courts all coming in, and they have to gather their evidence. They have to make sure their schedules are open just to get into this one trial date. And that might cost you a lot of time and effort and a lot of payments if you are paying out of pocket for your lawyer, which is going to cost you a lot. And in sense, if the criminal is being held in detention, it can lead to a longer prison date for them because they'll already be seen as a criminal and be dressed up in bright orange and be handcuffed. So it might not be as waived. So why do people plead guilty? It might be the easiest way. So out of all of the court trials and everything that has to get done from the attorneys meeting and getting the evidence and getting the witnesses, it might take a lot longer than they expect. So yeah, trials might be months ahead. A good lawyer could cost them anything from they're more expensive even though they have more practice. So like for the public attorneys, those are more overwhelmed, and so they're not going to be as prepared as if someone that you paid for, but they might cost them like a leg and a foot in this sense, not technically, but hypothetically. Like it might cost them all their money that they have in savings, and they might go broke or even bankrupt from it. So even if even if they are in detention, if they're held there, they're going to be spending more time in there. So that would lead to a harsher punishment. If they just plead guilty at the beginning, then they don't have to wait. They don't have to go through sitting around and waiting for everything, as well as sitting in detention, which could lead to more being viewed as a criminal, which could lead to harsher punishments. So faults in our legal system to tie in the pretrial process, it's going to play favorites. The institution is always going to be favorited over the worker because they're going to have more money, they're going to have more experience, and they're going to help boost the court's percentages of courts or of trials processed and trials won, whereas the worker is just majority going to waste its time and money. For economic bias, it's going to favor towards the institution because they're going to have more money and they'll benefit more from the laws that they produce. It doesn't effectively reduce crime. If someone gets arrested, then they get put into detention, which, if they're found guilty, they're still going to be sitting in there for a long time, which is not going to benefit them. And in this sense, they're just going to be sitting there while they're waiting for a trial date, and it's just not going to be well for them. And they'll probably be more pissed off at the system than with what they receive. Um, and those who in control make money off of those who gets convicted, but they have the power to change it. We've heard this one in the beginning, and in this sense, it makes sense, where it's the people that have the process to reduce the amount of wait time it takes for them to get a hearing is the ones that get the most money out of them waiting the longest. So they want to hold them off so then they can get the most money and be able to get the best out of the trial, where they just want to destroy the other people that get convicted.